Well, welcome back, everybody. This is the signing video series that we are doing. This specific video is in regards to the will, the last will and testament. So, just a reminder that the last will and testament is a little different from the old last will and testament that you would be used to. So, this one specifically, the purpose of it is to pour everything over into our irrevocable trust. If you recall from the Three Secrets workshop and the blueprint meeting, our goal is to get everything into the asset protection trust. Now, some things we can't put in during life, like the retirement accounts. Some things we don't want to put in during life, like money that we want to spend on a regular basis. So that's the purpose of the revocable trust for the assets that we want to leave in your name, but we want to avoid probate. And then the assets that we can put in the asset protection trust, we will put in during lifetime. But there will be stuff that over time, potentially you forget. Maybe you get a new account. You forget that you have these trusts and you put it in your name alone. Who knows? But the purpose of the will is to just getting everything over into that irrevocable trust so that after you die, we can have the provisions in that irrevocable trust govern everything. So the purpose of the will is much less significant because it's not going to actually house what's happening. We're going to have all that in the irrevocable trust. But in case there's anything left in your name alone at the time of your death, I need to get it over there so that the provisions in the trust are going to be what governs. So what I'll do is I will pull up the Mark Smith will. The will should be on your screen here. And if you take a look, this is the table of contents. So as I always joke, any good book needs a good table of contents. If you're ever looking for something, this is definitely the place to start. And this goes with any document that we have that has a table of contents. Always start there. That makes the most sense. And then as you get into the last will and testament of Mark Smith, here is where the actual document starts. I, Mark, being of sound mind and body, I am married and my wife is Sarah Smith, and we have 3 children, Dan, Jeff, and Reese. Now, obviously, we use January 1st for all of them, just because I was making up fictitious names and dates of birth, and I just simply wanted to make it as easy as possible. But please check the dates of birth of your children so that we're sure that that's right. If not, mark it. When you do your one-to-one review meeting, that would be something we definitely want to make a change of and discuss. Article 3, all just debts, cost of administration, funeral expenses shall be paid first and foremost. So that is just, standard phrase. Specific language here says after my death as is convenient. And that just simply means we know that we have to get the estate open. We know that we have potentially other creditors that could be in line as well, equal to or before them. So as soon as we can, we'll go ahead and get that stuff paid. Article 4, taxes, administration expenses. Again, same thing. Article 5 is pouring everything over into the irrevocable trust. One comment I do want to make is, and I will say this on the trust video as well, we did say in this case, the Smith family irrevocable trust, but we do not want to use the word irrevocable in our documents for you guys. I did that so that you knew which trust we were talking about. The way we identify revocable trust is by saying revocable, and the way we identify irrevocable trust is by saying family trust. If a bank or financial institution sees the word irrevocable, they get all weird because they don't understand. So yours will just say the Smith Family Trust, or whatever your last name is, Family Trust, unless otherwise directed. That information will be placed here in this paragraph, which will ensure that everything will get over into that irrevocable trust. I do add the ultimate distribution paragraph, just in case something crazy happens, or in case the trust is no longer in existence, or so essentially we're just getting everything to the closest family relative. And this has never happened in 20 years, but I just keep it in there. It makes me feel better. It certainly allows me to just, I don't know, have a fallback to a fallback to a fallback. I mean, this is a very remote contingency. So the chances of it happening are so slim that I would not, you know, uh, it's not something to worry about. But we have it in there just as a fallback, as a catch-all. Executor. The executor in the will is my wife, Sarah. In the event that Sarah can't do it, it will be my son, Dan, and my son, Reese, in the order named. This is another fairly recent thing that we did discuss in the blueprint meeting. We are recommending that you not say two people. We have gotten word from at least one bank, maybe two, that they don't want and even with an executor. So we're kind of in this dilemma right now. They opened it for me because of the relationship we have with them, but the truth is, because banking industry is telling people they don't want and they can't verify that two people are signing checks, similar to what we discussed on the financial power of attorney video. I always said it was just a matter of time until they started taking the same position with executors. And lo and behold, they did take that position in at least one case and at least one bank. So I left it here, but we did say in this one, in the order named, which means it is Dan first and then Reese. So we can do this. I could not say and make them act together currently. If you chose to do that, I always say that's okay. Just understand the risk, which is one of the children may have to renounce and agree to let the other one act. But again, that's currently only in a limited instance. So whatever you decided there is fine. I just wanted to highlight that. Article 8. So here we are under fiduciary powers. So similar to the financial POA, where we had to list specifically all the powers that were being granted, this is a very similar paragraph where we have to list specifically everything you're giving the executor, who is your fiduciary, the ability to do. And trust me when I say anything you can do, they can do for you after your death. I mean, it is as broad as we can possibly make it. It has to be. Again, there are going to be paragraphs in here that you may not completely understand every word, and you don't need to. It is more just about having it there in case we need to do it. And of course, giving authority for their signature to be able to bind the estate. Article 9, miscellaneous provisions and definitions. You will also see this in the trusts, both revocable and irrevocable. And essentially what this section is it's the most commonly litigated words, headings, and phrases. What we find is that people never fight over what mom and dad wanted. They fight over what mom and dad intended. Now, I know semantics, right? Everybody believes they're in the right and believes that they're doing what's best and what mom and dad would have wanted. But what gets us is mom had a conversation with brother, mom had a conversation with sister, and they're different. Now it's everybody fighting over the intent. And, the truth is, there's always three sides, right? Yours, theirs, and the truth. So what we do here is we eliminate all of this. The best common example that I give all the time is we had a stepchild that filed suit against an estate. Specifically, the law says that it's natural born or adopted, and you have to provide for. And the person did not intentionally and did not specifically name the individual either, because they had no intent of providing for them. We always take the kind of the position that we're going to name them if we want to include them. And because they wouldn't allow me to put a specific paragraph in there, not including them, they were able to sue. Ultimately, the estate won. Stepchild is not provided for, and they weren't included, so therefore didn't get anything. But it certainly was a lot of heartache. So now what we do is we define the most commonly litigated words, headings, and phrases. The word means exactly what the word is out of a dictionary. So we aren't kind of picking sides here, or we're just saying this is the definition. And what this eliminates is people being able to sue over the fact that you wanted the intent to be different. We are using the actual definition of the word, and therefore that is what we want if there's ever a dispute. So this section will eliminate tons and tons and tons of suits, because the word is the word, and that's what we want it to mean. We don't want people able to fight. If you intend something different, you're going to provide for it. You're going to specifically say it. So this is where you'll sign, 2 witnesses, and then on the next section, we're going to have you sign again. And this is just basically saying that you're not any undue influence. So that is the last will and testament. As you can see, much shorter than some of the older ones, simply because the intent is now very different. We just want to get everything over into the irrevocable asset protection trust. So again, we look forward to the one-to-one attorney review meeting. Please write your questions down and have them ready for the meeting so that we can be as efficient as possible in that meeting. Thank you very much, and look forward to seeing you on the next video. Thank you.